Mm. Good afternoon, everyone.
Good afternoon.
Good afternoon.
Okay, my
Good
apologies
afternoon.
for being tardy, but I had another class late. But anyhow, so everybody have an opportunity to collect their books.
Yes.
Yes.
All right.
Mhm.
And I hope everybody had an opportunity to read the first chapter. Yes.
Yes.
Oh, wonderful. Wonderful. So I can start off by asking you some questions.
Sure.
Okay. So what is meant by saying that a company is a separate legal entity? What does that mean? Don't all speak at once. Anybody? What does that mean? A separate legal entity?
It has an identity separate from its shareholders.
Correct. Anybody else want to add to that?
Liability doesn't extend to its shareholders.
Yes. Someone other than Denise. Let's go. I got a resounding. Everybody read. So let's just see if everybody understood the same thing.
The company can be sued.
Yes, it can. Anything else?
You cannot go after the shareholders only after the company itself and not what they have personally.
Okay. What else?
It owns its own assets.
Yes. No one else can think of anything else?
Even if the members and the shareholders of the company change, the company will still continue to exist.
Yes. Hold on, my phone is acting up. Can you hear me?
Yes.
Okay, all right, just making sure. All right, so let's start from the beginning of the chapter. Well, not the beginning, but we'll go all through. So when you speak about a company, there are two overarching principles that you must remember, and that's corporate finance and corporate governance. Corporate finance is about how a company raises money, and corporate governance is how a company is actually run. How does it achieve its objectives? So corporate governance is looking at the shareholders, the directors, the officers, the creditors, all of the stakeholders. So that's really one of the main areas that we'll focus on in company law, which is corporate governance. So when you talk about the company itself, the company attains its powers from its articles of association. And in your Companies Act, at the very end, there is an example of an article of association. Has anyone had the time to start to look at the Companies Act?
Yes.
Okay. Seeing the articles of association at the back?
Yes.
Okay, all right. So every company has an articles of association, and that is where all of the powers and the duties are contained. That tells how the company should be run, when meetings should be held, what they can borrow, what they cannot borrow, how many shares to be issued, what to do, and if there is a death. All of that is within that articles of association, which some shareholders tailor it to their needs. Now, when you talk about a company itself, a company is different from a sole proprietorship or a partnership. So someone tell me what is a sole proprietorship?
A company that has one owner.
One owner. And what else?
The liabilities with that sole owner.
And everything that that person owns.
Right.
Yeah, but there are some advantages of being a sole proprietor. One of which you direct your own company. You run it the way you want to run it. All the profits are yours. Similarly, when you have a partnership, what are the advantages of a partnership?
Is it shared liability?
It is shared liability. Anything else that makes this advantageous of having a partnership? Isn't it when you have a partnership, all of your business dealings are private?
Yeah,
Okay. And you
no
don't
obligation.
you know, right? And you don't have to publicize how much funds you are making. So it's private. But when you have a company has distinguishing features, different from a sole proprietorship and a partnership. And you mentioned it already that it has perpetual succession, but it also has unlimited liability. You said that too. But you also have that separation between ownership and management. Sometimes you can't see that in a partnership because the ownership and the management are sometimes done by the same persons. The same way it's done in the sole proprietorship. So that perpetual succession in terms of resignation, bankruptcy, whether someone is removed, you can see that as a dominant feature in a company versus a sole proprietorship or a partnership. Again, a partnership is based on an agreement and it can have provision in the event that there is a resignation or a bankruptcy or someone is just physically incapable of performing. In some instances where, and for shareholders, they have a shareholders agreement, and in that agreement, they would decide what happens to the shares of that shareholder. Normally, it's either the company buys it back or the other shareholders have the first option to purchase those shares. So this whole thing about a company came about with the case of Solomon versus Solomon. Who could give a summary of that case of Solomon versus Solomon? Why did the court decide that it was not his intent to defraud? And secondly, that he was not acting as an agent of the company? Why did the court decide that? How did they come up with that conclusion?
Was it because everything was outlined and the transaction or the daily dealings of the company. Is that-
1 point, yes. His transactions were not contrary.
And they deemed that the agent was not, the company was not an agent of its shareholders, I guess, by, due to the separation of, I don't know, separation of duties.
Yes. And even in Solomon, even though he owned the shares, he and his wife, the whole point of it is that once the company is incorporated,
Yeah,
once you have a certificate of incorporation in your hand, it becomes a separate legal entity.
right.
And unless that person had established that company with the intent to defraud, or if the court can determine that that company was acting as an agent of another company, then you cannot sue. And it was not Mr. Solomon's intention to defraud his creditors. But by him putting his assets in the company did not mean that he had the intention to defraud. So in the case of Macora and Northern Assurance, where the sole proprietor formed a company, he put the timber within the company as an asset. Then he financed the company. The timber was destroyed. And he wanted to claim from the insurance company. And what did the court decide? They decided that he could not claim for the assets because the assets belong to the company and not to him.
No insurable interest.
None. And the same thing in the Lee versus Lee's Air Farming, where the wife was establishing that her husband was an employee of the company. And that there was an agreement between her husband and the company to carry out the crop spraying. And that when he was killed in the act of his employment. And the court decided that he was an employee and that he should be compensated. So there are companies that are part of a group. And I know you know many examples where there are a group of companies that have subsidiaries and then they have affiliates. But there are two exceptions to the Solomon principle, that a company is an entity distinct from and not the agent of its shareholders. And that when there's actually an agency relationship between the company and its shareholders. And that has to be based on facts. And the second is when the structure itself is trying to conceal the true facts, or what they call a mere facade. So a parent company is a company that owns what they call the majority of the shares. So normally when a company owns 98%, 96% of the shares of a company, you say that it is a subsidiary of the parent. Now a branch is not a separate legal entity. All it has is a license and a jurisdiction to operate. But its mind and management is with the parent. A parent company cannot sue to enforce the rights that belong to a subsidiary. And a parent can be liable for the breaches of a subsidiary. But an agency or relationship can arise in a group of companies. And that's where the parent would have to plead that the subsidiary is an agent for that parent. And the court decided in the case of Smith, Stone, and Knight versus Birmingham, that for that relationship to arise, there has to be 6 factors that have to be considered. Who was carrying on that business? Who received the profits? Who was conducting the business? Who appointed those persons? Who has the head, or who was the head and the brains of the whole venture? And who was in control of the business? Those 6 factors help to determine whether an agency relationship is in place. Now, there are instances where the court would pierce the corporate veil or lift the corporate veil. And this is a matter that the courts themselves have grappled with over time, whether or not they really should be doing it or not. So the veil can be lifted by the judiciary or by statute. In the case of Conway versus Ratui, he said the readiness of the courts, regardless of the precise issue involved, to draw back the corporate veil to do justice when common sense and reality demand it. So what they're saying is that in the past, they would have lifted the corporate veil. But in today's world, they try not to circumvent that whole structure of a company having a separate legal identity. They're doing as much as they can to safeguard that corporate form and find other ways in which to provide justice to a person who's brought a claim. So the courts will lift the veil of incorporation where the incorporated is trying to avoid an obligation, or they're trying to get an unfair advantage, or where there is an abuse of the corporate form. Did anyone read any of the cases at the end of the chapter? No?
I read them. I can't summarize them.
Anyone did Jones versus Lipman? That one is short.
I know,
Someone-
very hard to follow.
Jones?
Any, unfortunately.
No one, okay, let me see if I can find an easy one that you could look up on the internet just to get an idea of piercing the corporate veil. Let me get one for you. Okay, so I just did Makora, Lee versus Lee. We'll put Guilford versus Horn. Anyone looked at that one?
I didn't.
You didn't? Anybody else? Janisa or Janicia? Because you have to read the cases in order to be able to understand when the courts are lifting or piercing the corporate veil, what does it mean? So in Guilford versus Horn, Horn was Guilford Motor Company's former managing director, and he had a restrictive covenant in his contract. Now, I did say he was former, so that means he's no longer employed. So to avoid this restriction in his contract, he formed a company. And after he formed the company, he went about doing the same business that he did with his former employer. So in the first instance, and the first instance means in the lower court, the judge had found that the company had been set up to enable the business to be carried on under his own control. So he formed the company and he was managing the company himself, but without incurring liability for breach of covenant. The reality was, however, that the company was being used as, quote, the channel through which Horn was carrying on his business, end quote. In fact, the judge dismissed the claim on the ground that the restrictive covenant was void. And you know what I mean when I say restrictive covenant? You know what that means?
No.
So restrictive covenant in employment means that, let's just say, let's just say in his line of business, his former line of business, he was selling only high-end cars. So he could have had a restrictive covenant, which means there's a clause in his employment says that when you leave this place of employment, you cannot engage in this business, nor can you solicit these clients. And sometimes they give it to you for a particular period. So what the court did in the higher court was that they issued an injunction against him, Horn, and his company for breaching the covenant. They say the company that Horn formed was in order for him to mask that he was carrying on this business. And he did that because he knew he was breaching the covenant that he'd entered into with his former employers. The shareholders and the directors of the company that Horn formed were his wife and one employee of the company. The judge said, I have not any doubt on the evidence I have had before me that the defendant company, Guilford, was the channel through which the defendant Horn was carrying on his business. Of course, in law, the defendant company is a separate entity from the defendant Horn, but I cannot keep feeling quite convinced that at any rate, one of the reasons for the creation of the company was the fear of Horn that he might commit breaches of covenant and that he might possibly avoid that liability if he did it through the defendant company. I am quite satisfied that this company was formed as a device, a stratagem, in order to mask the effective carrying on of the business of Horn. The purpose of it was to try to enable him under what is a cloak or sham to engage in business, which, on consideration of the agreement which had been sent to him before the company was incorporated, was a business in respect of which he had a fear that plaintiffs might intervene and object. So in this instance, once he left the place of employment, he formed his own company to do the same thing. And he did it with the disguise that they wouldn't know that it was him. Anybody else read any cases? Jones versus Lipman. Hold on. Okay. Jones versus Lipman. In this case, Lipman agreed to sell a property to Jones for 5,250 pounds, but he changed his mind. He formed his own company. The company had £100 in capital, and he made himself the director and shareholder. He then transferred the property, which he had agreed to sell to Jones, to this company that he had formed for £3,000. So in order to do this, Lipman had borrowed over half the money needed by getting himself a bank loan, and the remainder was owed to other people. So under the rules of the Supreme Court, the purchaser applied for specific performance to be carried out against the vendor and the vendor's company for the transfer of the property in question. And the court held that first, that the rules of the Supreme Court could apply to the circumstances. Then they said that the defendant's company was created by the defendant as a mask to avoid recognition by the eye of equity. And on this basis, a requirement of specific performance could not be avoided. It was clear that the defendant had control of the sham company which held the property, and therefore Lipman was the only individual who could perform the agreement. So let's go to Kate Adams and Kate Industries.
That
Hi.
there is mud
Go
to
ahead.
me. I don't understand that whole case.
Jones versus Lipman.
Yes, from it going from him wanting to sell to Jones and then forming a company, and instead the property is now owned by the company. I don't understand what charges or whatever were brought before him.
No, they,
I don't.
okay.
Yeah.
All right, so let me see if I could say it so you can understand.
Yeah, I don't know what eye of equity is. I don't know if anybody else does.
Would you call it just now? Eye of equity?
That's what I thought you read off just now. Yeah, eye of equity, recognition by the, to avoid recognition by the eye of equity.
Okay, so in law, when you go to the court to seek justice, you can go and ask for damages, or you could ask the court for equity. And when you ask the court for equity, the remedies could either be, you could ask for an injunction, which means as to stop the party from doing the act, or you can ask for specific performance, which means that the party must, as agreed in the contract, perform.
Oh,
That's what that is.
okay.
So in this instance, you're talking about property. So most likely, the remedy you're looking for is specific performance. You want the vendor to produce the documents for the property.
Hmm.
So in this one, Lipman is the vendor
Right.
and Jones is the purchaser. So Lipman, the vendor, says to Jones that he's going to sell him a piece of property for, I'll say dollars now, $5,000. Then he changed his mind. So that first sentence there is contract law. They entered into an agreement. Offer and acceptance. So they had an agreement. So that first interaction between them was an agreement.
Mhm.
Now, what Lipman then did was he formed a company. To put it in your mind now, put a company.
Mhm.
And normally when you think about a company, just make it a box. It's a company.
Mhm.
You form a company. And of course, to form a company, you need memo and arts,
Right.
a capital, and then you pay the fee and you get your certificate of incorporation. So when they say he formed his own company with a capital of 100 pounds, it means that he went through that whole process.
Right.
He made himself the shareholder on the register of members. He is the shareholder. On the registers of officers, he is the director.
Mhm.
So it's a one-man shop. You with me now?
Yeah.
Okay, all right.
Uh,
So he now has a company, but the company needs assets. So he transfers the legal title in that property from himself, Lipman, to the company. So now that piece of property that he was going to sell to Jones now belongs to the company.
I see.
Okay. Now, once he transferred that property, knowing that he had agreed to sell it to Jones, and he transferred to this company incorporated for 3,000 pounds. Remember now, he was selling it to Jones for 5,000.
Right.
So to enable him to do this, how did he do it? He
Oh, you mean
borrowed,
through creditors? Okay.
right, creditors.
Mhm.
He borrowed it.
Right.
So they're saying that based on the transaction, the purchaser, which is Jones, can apply for a specific performance because this was a contract between vendor and purchaser. So the court said it found out that Lipman Company was created by him to avoid being fair. And specific performance could not be avoided. It was clear that Lipman had control of the sham company, which held the property, and therefore Lipman was the only individual who could perform the agreement.
Mhm.
So he put the property within the company so as not to sell it to Jones, because he's saying he no longer owns that property. The company owns the property,
Mhm.
but he had already entered into an agreement with Jones to sell the property to him. So that's why the court then determined that they would grant specific performance which means that Lipman had to sell the property to Jones.
Okay.
Clara?
Yes, much clearer. Thank you.
Okay. All right. So when you talk again about Pearson, the corporate veil, people talk about the case of Adams and Cape Industries. And in Adams and Cape Industries, they spoke about 3 different categories of when the corporate veil can be pierced or lifted. When there's a single economic unit, or there is a fraud or sham, or there is an agency relationship, like I said earlier. So in Adams and Cape Industries was an English company, and it mined and marketed asbestos. The worldwide marketing subsidiary was another English company called Capasco. It also had some US subsidiaries, one called NAAC. So in 1974, they were sued because of personal injuries based on the asbestos. And they settled these claims. And then between 1978 and 79, more claims came about, and a default judgment was entered into against Cape and Capasco. In 1978, NAAC ceased to carry on business, and what Cape did was they incorporated other companies to replace NAAC. The plaintiffs sought to enforce the judgments in England, and the defendants denied that the Texas court had jurisdiction over them for the purposes of English law. So you're talking about a group of companies that operate in different jurisdictions. And the Court of Appeal held that the defendants were neither present within the United States, nor had they submitted to the jurisdictions there. The method of computing damages of the individual plaintiffs was contrary to English law concept of natural justice. And of course, the actions were dismissed. So the court looked at piercing the corporate veil under a separate legal or separate economic unit, one unit. And they say the general principle is that all companies and group of companies are to be regarded as one. There is no such general principle. The fundamental principle is that each company in a group of companies is a separate legal entity, possessed of separate legal rights and liabilities. So in the case of Cape, Capasco, NAAC, and CPC, CPC was the company that was incorporated and replaced NAAC. They were separate legal entities. Mr. Morrison didn't go so far as to submit that the very fact of the parent-subsidiary relationship between Cape and NAAC rendered Cape and Capasco present in Illinois. Nevertheless, he submitted that the court will, in appropriate circumstances, ignore the distinction in law between members of a company, treating them as one, and it will do so whenever it considers that justice so demands. So what the court does is it investigates the relationship between the parent and the subsidiary. And they're trying to determine whether or not the subsidiary is acting as an agent of the parent. And if they are acting as an agent of the parent, then on what grounds are they doing it? Terms of agreement. So in that case, Morrison stated that the court will lift the corporate veil where a defendant by the device of a corporate structure is trying to invade limitation that is imposed by law, or such rights or relief against a third party, or rights and relief as third parties may in the future acquire. So either they possess these rights now, or these are rights that they're going to get in the future. Then the courts tried to argue that there was an agency relationship to NAAC. Again, the court says that NAAC was a separate legal entity, separate from CAPE, which was the parent, and separate from Capasco, which was an affiliate. So the court said that the judge was right to hold that the business carried on by NAAC was exclusively its own business because it was a subsidiary and not the business of CAPE or Capasco. And that CAPE and Capasco were not present within the United States through NAAC at any material time because each one of the entities was separate subsidiaries. And the court said we see no sufficient grounds for disturbing this finding of fact. In the case of Chandler versus CAPE, the Court of Appeals sought to outline the circumstances in which it could impose responsibility on a parent company for the health and safety of employees of a subsidiary which was no longer in existence. And in that case, it was held that the parent company owed a duty of care to the subsidiary's employee who had developed asbestos after exposure to asbestos dust. So in the case of Press or Petrodel versus Press, we see where the court start to change in terms of whether to pierce the corporate veil or not. So in Press versus Petrodel, the appellant wife, she appealed against a decision from the lower courts because she was challenging some properties that were owned by her ex-husband. But these properties were operated and controlled by him. So X as the company was the legal owner of 7 residential properties. The trial judge concluded that the husband was entitled to possession or reversion of those properties within the Matrimonial Causes Act. And therefore that entitled the court to pierce the corporate veil and ordered him to transfer them to his wife. The question on the appeal was whether the court had power to order the transfer of those properties of the husband, given that legally they belong not to the husband, but to the companies. Consideration was given to 3 possible legal bases on which the assets of the company could be available to satisfy the lump sum that was being requested against the husband. The case was one where exceptionally the court could disregard the corporate veil in order to give effective relief. And under the act, it conferred a distinct power to disregard the corporate veil in matrimonial cases. Or the company held the properties on trust for the husband, not by virtue of his status as sole shareholder and controller, but in the particular circumstances of the case. So under English law, it enabled a court in very limited circumstances to pierce the corporate veil. And that's when a person was under an existing legal obligation or liability, or he have some existing legal restriction, which he is deliberately trying to evade. So in this case, the court could pierce the corporate veil for the purpose only of depriving the company or its shareholder of the advantage that they would otherwise have obtained by the company's separate legal personality. So although the husband had acted improperly in many ways, his actions had not evaded or frustrated any legal obligation to the wife, nor had he concealed, excuse me, or evaded the law in relation to the distribution of assets of the marriage upon its dissolution. And accordingly, the piercing of the corporate veil could not be justified. So you see, the court is now making a distinction. It tells you that you can pierce the corporate veil in certain circumstances. But in this circumstances, the court is telling you that the husband himself hasn't done anything improper. He didn't conceal anything. And he didn't try to evade any legal obligation. So then, how is this wife to be compensated for these assets that she is claiming? So the court decided that they would use trust principles and award the wife 3 of the homes. So following the decision in press, the courts have continued to approach veil piercing cautiously and sought to limit its use. So the court always tried to avoid the abuse of the whole corporate form, because the whole significance of incorporating the company is to ensure that you have your assets protected within that company, that it is a separate legal entity. So if we look historically around World War II, English courts, they experimented with the different approaches to the whole Solomon doctrine. What did it mean? How does it function? And then in the second period after World War II, they began looking at, again, at the corporate personality of a company. And then in the third period, which is now, the principle now is focusing more on adopting a more cautious approach to piercing the corporate veil. Any questions so far?
Yes, just regarding the cases, are all of them in the book or do we have to look some up? I know when we were talking about
Some that we
Guilford
can look
Motor, some you have to,
Yeah.
okay. Guilford
Some you-
Motor, okay, thank you.
And the more you read, then you really begin to understand how the courts are protecting this whole concept of separate legal or that separate personality, because that's the gist of what a company is.
Thank you.
I'm going to assign some cases before we finish, so everybody can have a chance to present a case. I'm looking up DHN. So DHN, Food Distributors and Tower Hamlet. DHN was a holding company in a group of 3 companies. Everybody understand what that means? So there are 3 companies, and at the top of those 3 companies is DHN. DHN is the holding company, so it holds at the at the very top, those three companies, the profits that they make go up into the holding company. So there were two subsidiaries wholly owned by DHN. One subsidiary owned land used by DHN. The other owned vehicles used by DHN. The land was subject to compulsory purchase, and DHN sought compensation for disturbance of its business. Any questions there? You know what compulsory purchase is?
No.
No.
Okay, that's when the government acquires your land.
Mm.
So normally when the government acquires your land, they will give you fair market value for it. But DHN has decided that they're going to sue for disturbance of their business also. So in this case, in the Court of Appeals, they said, quote, these subsidiaries are bound hand and foot to the parent company. Because remember now, one was owning land and the other one was owning vehicles. All of them were by DHN, the holding company. So you have a holding company at the top and you have three subsidiaries underneath it. So the judge says that these subsidiaries are bound hand and foot to the parent company and must do just what the parent company says. This group is virtually the same as a partnership in which all the three companies are partners. They should not be treated separately so as to be defeated on a technical point.
Sorry.
Go ahead, Denise.
No, I guess you can't. No worries. Never mind. Sorry for the interruption.
What happened?
I did something on my computer that was making noise. I don't know if y'all can hear it, so that's why I said sorry.
Oh, no, we didn't.
Okay, sorry about that.
Okay, so it was held that DHN was entitled to the claim. The separate corporate personality doctrine was overridden. However, this is likely to only be followed where the subsidiaries are wholly owned and serve no purpose other than to own the parent company's assets. This case has not, or the case has not been applied to make one company in a group liable for the debts of another. So you see, DHN is different from Adams and Cape because the structure is different. The purpose for which the companies were established were different. Because in DHN, the subsidiaries holding assets on behalf of the parent, and the acts that it carries on are on behalf of the parent. And so they were able to sue for compensation for disturbance of its business because the subsidiaries and the parent work hand in hand. Any questions on that one?
No, but a comment. So, if an injury had occurred as a result of somebody driving one of the vehicles that was owned by the subsidiary, would the same, due to that structure, would the same principle apply in that the holding company would be liable in that case?
Now, don't forget now, when it comes to employees driving the vehicle, that's a strict liability.
Strict meaning just to that subsidiary, that company that owns the vehicles? That's what you mean?
Yeah. You're gonna have to prove that the parent itself. Remember in the other case where in Chandler, where they said that the parent had the duty of care.
Right.
So again, it comes to whether or not the parent has a duty of care for the vehicles that are being operated by the subsidiary. So that is what's going to have to be proved. Was it their responsibility?
Because otherwise there'd be no purpose to separate the assets then, eh?
Mm-hmm. Exactly.
Okay.
So in the case of Press versus Petrodel, which you all are going to read for next class, everybody, one person will present it. The courts are questioning whether or not the decisions in Guilford Motor and Jones and Lipman were correct.
Say that again?
I said in the case of Press versus Petrodel, the
Yeah,
court is trying to just going back at all the other cases, they're
yeah.
trying to put in their mind whether or not the case of Guilford versus Horn and Jones versus Lipman, were they actually correct?
All right.
So when it comes to abuse of the corporate form, this is when you're looking at whether the courts are willing to lift the corporate veil, is where the actual company is being used as a facade or a sham or a mask to evade some existing liability. And you saw that in Guilford Motor Company versus Horn and Jones versus Lipman, because that's what Lipman was doing. He put the property within the company so that he didn't have to sell it to Jones.
Right.
So another way, another instance is a group of companies. Again, the courts have on occasion lifted the veil to allow a group of companies to be regarded as one, because in reality, they were not independent either in human or commercial terms. And the current approach to that was taken in the case of Bank of Tokyo versus Corone. And there the court says that counsel suggested beguilingly that it would be technical for us to distinguish between parent company and subsidiary in the context. Economically, he said they were one, but we are concerned not with economics, but with law. The distinction between the two is in law fundamental and cannot be abridged. So again, they are holding steadfast to the concept of a company being a separate legal entity. And then of course, there's always the concept of agency when you have a group of companies. And that is used by the courts when a subsidiary is regarded as the agent of its holding company. So even though there is no agency agreement between them and the transaction concerned, the transaction entered into by a subsidiary are regarded as those of the holding company for which the holding company is liable. The doctrine has been implemented for the purpose of liability of tax. And then you have illegality. So courts are prepared to draw aside the veil of incorporation to establish that a company was owned by nationals of an enemy country so that to do business with it would be illegal, because then it would be trading with the enemy. And the case for that is Daimler versus Continental and Ibrahimi versus Westbourne. And of course, you have statutory provisions. And Lord Diplock in Dimpley versus the National Union, he observed that the corporate veil in the case of companies controlled under the Companies Act is drawn by statute, and it can be pierced by some other statute if such statute so provides. But in view of his raison d'etre and his constant recognition by the courts since Solomon versus Solomon, one would expect that any parliamentary intention to pierce the corporate veil be expressed in clear and unequivocal language. So again, you see, even as late as 1984, the courts again are trying to protect the separate legal personality of companies. So the concept of being fair and justice don't play a leading role in the court's decision on whether or not they're going to lift or pierce the corporate veil. The prevailing attitude of the judiciary is that those individuals who adopt the corporate form should expect to take the highs with the low. The significance of the Solomon Principle in relation to property is that the company is the beneficial owner of its own property. Let's remember the case of Makora and the timber. It doesn't hold it as trustee for its shareholders or its members. And the shareholders and members do not have a legal or equitable interest in the property. Shareholders or members cannot insure the property of the company because they don't have any legal or equitable interest. Any questions on that point? Because that's the point that a lot of persons, when they form a company, are under the misconception that they can insure the assets or that they have an interest in the property once they have transferred it to the company. No questions?
So once transferred to the company, I guess pretty much you're saying they have no
Interest.
lots. Okay, it's done away with.
Yeah. It belongs now to the company.
Company.
So they cannot act as if it is theirs personally. And that's the key to forming the company. So a company being an artificial legal entity is just like you or I. They can enter into contracts. It is an artificial being. So they can enter into contracts, they can sue and be sued. So in a company, you have persons who can interact on behalf of the company. And the board ratifies those positions. Those are the officers. So a shareholder cannot enforce a contract because he is not a party to the contract. Who can enforce a contract in a company? Let me ask you.
Directors,
Yes, and who else?
creditors, maybe,
The CEO?
yeah, employees, perhaps.
Yes, certain
Uh-huh.
employees who are authorized.
Mhm.
And a shareholder cannot be sued on contracts by the company.
Right. Can I just
The
ask
court-
a question, please?
Go ahead.
This Brenda Hannigan, going a little off topic, this, it says according to Brenda Hannigan in company law, I saw that that was supposed to be the textbook for this course. Is that
Mhm.
accurate? In other words, will there be material that's in that is not contained in this handout that we need to be aware of?
No,
Okay,
no.
great.
Just what you see here, and then what I may give you for homework or we discuss. No.
Okay, thanks.
You getting scared already?
No, I just wanted to know if there was additional material that
No,
is in that
no.
textbook, since it says
No.
that it's it's required. Mhm.
Yeah. No, I think it'll be a little bit too much.
It's already too much for sure.
No, it's
Okay.
not that much.
Mm,
A court can compel a shareholder to vote at a general meeting that will ensure contractual obligations. It's not structured that way. So a company can sue in respect of torts committed against it, and it can be sued for torts committed by it. And normally torts are committed by the agents of the company, the directors and the employees. So a company is liable for the acts of its agents as long as they're acting within the course or the scope of their authority, the course of their employment, scope of their authority. And in the case of Lloyd versus Grace, Judge Blackburn, quoting from another case, McGowan versus Dyer, stated that the general rule that the principal is liable to third parties in a civil suit, and he is liable, that's the company, for the fraud, any deceit, any concealment, misrepresentation, any tort, negligence, and any other malfeasance or misfeasance or omissions of duty of his agent in the course of his employment. And that's why you see even in banks, they're very careful. When you go to someone, you ask them a question, they'll always say, what? I have to refer, or let me speak to my supervisor. And that's always because they have to take it up the chain of command to the person who has the authority to respond to the questions. Again, so that the bank is not sued for negligence. Or they can be sued for misrepresentation. So it says here now that the tort or negligence occurs in the course of the agency. For the principal is not liable for the torts or negligence of his agent in any matters beyond the scope of the agency, unless they were expressly authorized to do so. So that's why you see when persons are driving the employer's truck, they now have a monitoring system on those company vehicles to make sure that you are actually going where you should be going on behalf of the company, because it exposes the company to liability. Now, whenever a director acts on acts that are not his own, then of course he's going to be personally liable. But this doesn't happen if the director becomes a joint tortfeasor with the company. And that happens when the director himself has authorized, directed, or procured the wrongful act himself. So if the director is carrying out the duties entrusted to him by the company, all in accordance with the memo and acts, the circumstances for holding him liable as a joint tortfeasor would be infrequent. So even as a director, you have to know what are your powers and your duties within the ambit of the Articles of Association. In the case of MCA Records versus Charlie, the justice emphasized that the question is whether the individual, that was the director, has been previously involved in the commission of the tort to a sufficient extent. That is whether the individual will be liable as a joint tortfeasor with the primary infringer, who was the company. That is whether or not the relationship between the individual and the company was one that the individual was a director of the company. And two principles were set out. A director will not be treated as liable with the company as a joint tortfeasor if he does no more than carry out his role as set out in the Articles of Association. And again, it comes back to when I started, that all has to do with the governance of the company. And secondly, a director will be liable with the company as a joint tortfeasor if he participates or is involved in the wrongful act that goes beyond the exercise of his control set out in the Articles of Association. So a director himself, he can be liable on his own, regardless of whether or not he is a director. So even though a director can be liable on his own for tort, even a managing director or CEO can be liable on their own for a tort. And in the case of Standard Chartered versus Pakistan National Shipping, the managing director and the company was sued in deceit, and the company was held liable. And on appeal, the court ruled that the managing director was not personally liable, as he had made the fraudulent representation on behalf of the company and not personally. So the bank appealed to the House of Lords, and they were successful. Lord Hoffman stated that the managing director had made a fraudulent misrepresentation to the bank, and the bank relied on it. By the law of agency, this representation and the knowledge was attributed to the company. However, the fact was that the representations and the knowledge were that of the managing director. He was the only human involved in making the representation to the bank. The managing director in this case was being sued not for the company's tort, but for his own tort. He was not liable because he was a director, but because he committed a fraud. So a director may also be liable for a negligent misstatement if there is an assumption of responsibility and reliance was made on that assumption. Of course, again, as a separate legal entity, a company can be sued or is subject to criminal law. Statutory offenses which give rise to vicarious liability on behalf of an employer for the acts of his employees in the ordinary course of employment. Liability may still occur even though the company's management has forsaken its employees to behave in a particular manner. So in these instances, the court seeks to determine who is the directing mind and will for the purpose of the liability. And you see that a lot in company law. When matters go before the court, that is always the question. Who has the directing mind and will for the company? Who's the person giving the instructions? That is key to understanding who is operating the company and where liability should rest. Any questions?
I don't think I clearly understand agent and principal.
Okay. So you work for Glass Paper Company Limited. You're an employee. So as an employee, when you perform your duties as an agent of the company. The company is the principal. There's a contract between you and your employer.
Okay.
Every act that you carry on between 9 to 5 should be acts on behalf of the company. That's why you see certain companies have different restrictions during certain hours because you represent the company.
Okay.
Okay.
Thank you.
Not a problem. Now, I have a question. Let me see. No, that wouldn't do. Let me see what I want to ask you. A fundamental attribute of corporate personality is that the corporation is a legal entity distinct from its members. What would you say are the two outstanding advantages of incorporation?
Sorry, could you repeat, please? My laptop went blank.
Okay, a fundamental attribute of corporate personality is that the corporation is a legal entity distinct from its members. What do you think are the two outstanding advantages of incorporation?
I can try and answer. I'm not sure I would be right.
No, try.
I'm thinking when you incorporate the company, it absolves all, I guess, chances of you being sued as the owner of the company.
Mhm. Anybody else?
I think I was going on the lines of Shanice. When I heard distinct from members, I thought like liability.
Okay,
You don't bear the liability as a member.
mm-hmm.
Separation of ownership and
Separation,
management,
yes.
perpetual existence.
Mm-hmm. If I gave you that as an essay, right? And I asked you to tell me, you've given me your answer. You've given me two outstanding advantages of incorporation. Why? Why did you select those?
You mean because based upon Solomon principle, you mean bringing that into it?
Mm-hmm.
And I mean, are you referring to other cases that support the separation of a
course.
company as a legal entity?
Yes, you're getting there.
So Guilford versus Horn and Jones versus Lipton or whatever it was, Lipman.
You remember those two now, right?
Oh, I wrote this down. So when you ask a question like that, obviously, we are expected to go into detail or explain that case law to support the two defining features of
Yeah.
the incorporation of a company.
Yes,
Okay, great.
yes.
Yeah. Well, I won't be able to do that right now.
No, you can't do it right now. You just
Oh,
started getting a feel for,
right.
yeah, what it would look like.
Mm.
So with that said, you know, we have midterm. Midterm is take home. You'll get it a week before. And along with this class is a capstone. And a capstone is more research-based, or it can be looking at a particular case and giving your views on it from company law. It could be more than one question. It could be two, it could be three, or it could just be one research question. It could be where you have to look at other jurisdiction and look at our existing laws and make recommendations. I haven't decided yet what the question will be. I like to start the class by asking people to think about it, and then for the next class, give me a feel of what you prefer. Some people prefer if I just give them straight out questions. Some students say they prefer research question.
Straight out, I'll tell you right now.
I second that.
Honestly.
Agree, yeah.
Okay, right. Not a problem.
I don't know about y'all, but I'm 53. I haven't written a paper in plenty years.
I've written it down. I heard 2 persons, so I'm going with that.
Can the other people please speak up?
Straight up
Straight out,
questions.
yeah, straight out, it's fine.
You're okay with
That's fine.
the midterm being take home?
Absolutely.
Yes.
You know, the final is in class.
We
Okay.
don't have an option on that too?
No, it's in class.
Is it open book?
No,
Are you kidding?
no, I'm serious.
I hope it's multiple choice then.
Oh, no,
Can I back out?
no.
Okay.
By then you will find that for the final exam, okay, let me tell you what I do.
Tell me.
Midterm, of course, I don't need to tell you what's on the exam because it's take home.
Yeah.
For the final exam, my review, which will be half an hour at the end of the class, I actually tell you the areas that are coming.
Great.
So you don't have to guess. You don't have to go all
Okay.
over. You just listen very carefully and you make your notes. And if you study what I tell you to study, you won't have a problem.
Okay. I like it.
So it's no, you don't need to stress yourself.
That's
Now-
not a little tricky.
No, it's not tricky.
No, that sounds good. So I know
No.
we won't have to worry about joint tort feasors on that.
No, no. So let's
Yeah.
find some cases,
Okay.
and that's really to force you to read. So you have to present. What home means? I don't know what home means. Let's
It
see.
means, oh boy.
It means excitement.
Of course. To El Aljou versus dollar. That's
Oh,
number.
that's 14?
Denise?
Yes.
Okay. Someone to do Firestone and Llewellyn.
I can do that one. Which one is that? Number 16?
16.
I'll do that. This is Christina Marie.
Okay. Meridian Global Funds versus Securities. Wilson?
Could you please repeat? I'm here looking for it. Which number is it?
24.
Okay.
Okay. I'm trying to find some that's not too. Let's just someone do 42, Standard Chartered versus Pakistan, the one I summarized. Volunteer, Miller.
Yes, ma'am.
Number 40.
Okay, and so we're starting with Standard Chartered Bank versus Pakistan.
No, we're not starting with that.
That's what you're
Okay.
presenting.
Just presenting.
Okay, okay.
Okay, someone to do 48, Williams, Natural Life. Carolyn.
I can do that. I can do that one. This is Carolyn.
Okay, all right. I have you for 48.
Mhm.
I need someone to do Press versus Petrodel.
Okay, if you let me leave me, so I'll do 51.
Okay, so that's Bar. Did I leave off anybody?
I didn't get one. Well, I didn't get a chance to say. I need something that's not too difficult, Miss Archer.
What-
Thank you.
Don't we all?
All right, I know.
What is all of that?
I need something. I need something.
I know.
And
That's all of us, by the way, if you need to make any modifications.
252.
Sorry.
Sorry, Miss Archer, we're presenting these, Commissioner.
No,
No.
next week.
Week.
Oh,
Oh,
next week?
sorry.
Yeah.
Oh, Lord, okay.
52 is Antonio.
Mm-hmm.
Antonio Gramsci. Okay, so
Shipping.
when I read this tomorrow, Miss
Mm.
Miss Archer, because I ain't gonna lie to you, I'm not gonna read this tonight.
Mhm.
When I read this tomorrow, and if I don't understand, I'm gonna private message you, okay?
That's not a
We can
problem.
change that. We can change this around. But yeah, I can try my best.
Okay, if not, yeah, then fine. There's many more here.
Yeah.
Private messaging is an option. I don't have that link.
You don't need that link. My email is
You know, just what guys in an email.
I'm kidding.
just send me an email and then I will just choose another one. That's not a problem.
So I'll have to Google this case.
Yes.
Okay.
They come up on Wikipedia too, and it's a little easier to read.
Yeah.
Okay. Wikipedia. All right. Thank you.
So, sorry, what's the format of our present? This is like a 2-minute thing. Like, how
2
are we
minutes.
presenting these?
Tell us what was the issue, just like how I did in once. What was the issue from a company law perspective, and what did the court decide, and why?
Okay, thank you.
Yeah. So it's not going forever and ever all over the place. But if you have to answer a question on, like the one I gave you on terms of that separate legal entity, why incorporation is important, you will have at least 1 or 2 cases already mentally in your head that you can use. Yeah.
Hopefully, yeah.
Hopefully, yes, you will. Yes, you will.
I believe in miracles.
Yeah, it can happen. It can happen. All right.
Okay.
Okay. So for next week, I will see if I can have your capstone questions. Start to put them together. You want 2 questions, 3 or 4?
Depends how involved they are. I'd like just one.
I could take 2.
She said she could take 2. Let me see what I can.
Wow.
Let me see what I can come up with.
These questions, the responses, is there, I mean, surely there's some guidelines for the responses, huh?
No, not really. You're just answering the question, providing case
Okay.
statute where relevant.
The beginning of this coursework book was very scary when it almost seemed like you had to present a very highly developed paper with bibliographies and everything. I almost asked for a refund.
No, that's the
I'm serious.
standard requirement for capstone, for all the courses.
Mm,
But in company law, how my questions are worded, you don't need a bibliography. If you're doing research, then you would have needed one.
right.
Yeah, you're not doing a research question.
No,
These are,
okay.
yeah, so that's not necessary. But if it was research based, yes, you would have had to.
Mhm.
But don't worry,
Okay.
okay?
All right. Thanks.
So all those who feel enthusiastic can start to read their cases now.
All right, gonna sign off and go start reading. Not.
Miss Archer, sorry,
Yeah.
I'm not. I have your email. Actually, did you provide us with an email?
It's
I'm
in the
not
thing with the Zoom
Is in the
link.
thing? Oh, it's already in there? Oh, okay, okay.
Yeah,
That's what I.
So we
assumed.
can email you if we have questions.
yes, ma'am.
Okay, thanks.
Mm-hmm. All right, so enjoy the rest of your weekend. Think company law, company law.
So next
Okay.
week we'll be going over unit 2.
Yes, we'll do the cases first and then we do unit 2.
Okay, so we'll just need to read unit 2.
Mm-hmm.
Okay, thank you.
All
Thank
right,
you. Okay.
okay.
Thank you.
Done. Okay.
Bye-bye.
Okay, bye.
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 Bye-bye.
Okay, bye-bye.
Bye.
Yeah.